breaking into that building, taking a Nike jacket, is that worth this time of your life away in custody? 5CR013828. Can I have parties announced for the record?
Ready for the state.
Teresa Garcia for the defendant.
And are you Mr. Sanchez? Counsel, have you received all discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Judge.
Mr. Sanchez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Sanchez, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with burglary of a building. Normally, that's a state jail felony with a range of 180 days up to 2 years in the state jail facility and up to a $10,000 fine. The state is proceeding on your on the indictment as a habitual offender enhancement. So if the state is able to prove up the enhancement allegations, then your range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Do you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand? By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Sorry. Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, can we go off the record for a moment?
So instead of the third degree, was to the second degree. So that we have to be looking for 2 to 20 years.
And if y'all just scratch through the other
Yeah.
one?
And do you want him to initial where we scratch?
Yes, please. And I'll instruct you on that as well.
My apologies.
Oh, no problem. State jail felonies are different creatures.
We open on a simple theft, a Nike jacket. But don't let that fool you. In this courtroom, small choices can snowball into life-changing consequences. Watch how fast this escalates.
All right.
But that's why I was double checking. I'm like, I think.
Yeah, thank you, Judge.
And so that was throwing me off. I was like, oh, what I'm going to do, since y'all just initial that, I'm just going to.
Yeah, that's it. You did.
All right. So we're back on the record.
Yes.
So with regards to your state jail felony, burglary of a building, if the state proves up that your 2 prior enhancements were offenses that were felonies other than a state jail felony, then your range of punishment will be as a second degree, anywhere from 2 to 20 years in the prison and up to a $10,000 fine. Do you understand? All right. All of the other instructions that I've given you or admonishments that I've given you, they will still be the same. So has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, did you agree that you've been previously convicted of 2 or more felonies for enhancement? Punishment is to be assessed at 2 years in the prison. Did you understand that to be the plea? Defense?
Yes.
State?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Judge.
Pause right there. Normally this would be a state jail felony, relatively low level. But because of prior convictions, the state is seeking a habitual offender enhancement. That transforms a 2-year max into a potential 2 to 10 years in prison. This is where the case gets serious.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? To both enhancements, how do you plead? True or not? State any evidence to support the defendant's plea?
Judge, we offer to say exhibit number 1 with all of its attachments.
No objection.
All right, State, you may be excused.
Thank you, Judge.
Sure. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, this is something that he did. He was having a hard time, and we ask that you follow the plea bargain.
How old are you? All right, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served, request a therapeutic community, and there's to be no residing in.
Think about that. The difference between months in state jail and a decade in prison all hinges on those prior cases. Would you roll the dice on that?
Households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You got some decisions to make. Breaking into that building, taking a Nike jacket, is that worth this time of your life away in custody? You're going to have to start making better choices. If you don't, what's going to end up happening is you're going to see your life passes you by. And I'm sure your attorney can tell you, I know I can. Once you reach 29, well, really 21, the years just fly by. You wake up, half your life is gone. So if you don't get it together, that's what's going to end up happening. Or you may break into somebody's building and they don't like it. You understand? All right, good luck to you. Welcome.
May we be excused?
Yes.
You did say credit for time served, correct?
Yes.
Okay.
So let me ask you, court is calling 2025 CR 005277, State versus Luis Molina Lucas. Could I have parties announced?
Rick Pena for the state of Texas.
Non-Trevino for the accused.
And are you Luis Molina Lucas?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Luis Molina Lucas who is placed on deferred adjudication in 2025 CR 005277 for the offense?
What the judge just explained is a major shift. Because the prior felonies aren't state jail felonies, this burglary is being punished as a second-degree felony. That's a massive jump in exposure, up to 20 years. Every word of this plea now carries real weight.
A violation of bond or protective order, assault, stalking on May 29, 2025 for a period of 4 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 19 on or about the 24th day of December 2025 in Bexar County, Texas. The defendant, Luis Molina Lucas, removed, tampered the radio frequency device, ankle bracelet, without the permission of the supervision officer.
All right, to that, how do you plead? True or not true?
True, ma'am.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you to 10 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 19? And do you still wish to plead true to that? The court will find violation of condition number 19 true. Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion, revoke the defendant's probation, sentence him to 3 years TDC.
All right. Does anybody want to talk to me about the circumstances regarding this removal or tampering with GPS?
Well, Your Honor, the defendant was very scared at the time. He wasn't thinking. I'd rather let him explain it to you, but
Okay.
he was trying to get into Haven for Hope.
I didn't feel comfortable staying there anymore without any work. So as a man, it kind of hit my pride staying there for so long.
Here's the thing. I'll have you raise your right hand.
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Louis Molina Lucas.
All right. So you were saying that you were in fear or your pride was in the way of you going into.
Oh, no. I felt because it was prior to that we had issues. I guess they had always told me trying to leave the house because of not working. I guess.
Now, were you living at that house? Is that where you lived?
Yeah, that's where I was living at.
And was she living with you at the time?
No.
Why were you there?
All because of through a mutual friend. We knew the woman, and she let me stay there for a little bit.
But you were trying to find alternative housing as well, right?
Yes, I had to talk to my probation officer as well about that, and the monitor people that I needed someone to stay. But they said till the court approved it, I couldn't really leave.
Did the person that's named in the original case that you have for not stalking out, filing a protective order, she has.
And just like that, no trial, no witnesses, no jury, the case is over. With a single finding of guilt, Mr. Sanchez's future is now in the judge's hands.
Her own place to stay, right?
Yeah, I believe so.
And you had did you have any reason to believe that she'd be coming over to even set eyes on you?
Oh, no, not really.
Okay. So is that the only circumstance as to why you saw her?
Oh yeah, and that's when I took off.
You took off?
Yeah.
Where'd you go?
Oh, I went straight for Haven for Hope, but because of Christmas, I guess it was Christmas Eve. It was closed that day. They let me in the next day.
Do you have anything else to say?
I'm still trying to figure out and have it explained to me because I'm trying to figure out your thought process. I still don't understand how that equals to you tampering with your GPS.
I just panicked, man. I just wasn't used to it. I just went straight for it. I just Haven for Hope. I don't know. I just panicked, to be honest. I just never been in trouble like this, and I just didn't know what to do. This is actually my first time getting in trouble, serious trouble.
Yeah, because I was like, because this is not his first case. Am I right in assuming that? Well, I'm just like, this isn't the only criminal case he's had.
No, but it wasn't nothing. I say, I guess like a felony case. I ain't never had a felony case.
You know,
I'm just kind of panic.
you suffer from anxiety.
Because I had come from a rehab before I come to San Antonio, and yeah, they actually gave me pills for that.
For anxiety?
Yeah.
Okay.
Probation, what has he done on probation? Has he done anything?
Judge, it appears that he was discharged unsatisfactory from the outpatient program. I don't see that he's completed the BIPP. He completed his TAP evaluation and his parenting classes, and for the community service hours was giving credit because the parenting classes were complete, and he's paid a total of $384 toward his fees.
All right. Court is going to find you guilty, revoke, sentence you to a $1,500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's been no contact with the complainant. Court will request the therapeutic community. The court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Do better, okay? All right, thank you. What's next?
This is more than a sentencing, it's a life lesson from the bench. The judge isn't just punishing a crime, she's warning him about the long road he's on. The question is, will he listen?